What happens when a privately appointed receiver takes control of your business assets? It's a gut punch that can leave any entrepreneur feeling powerless. In this Brandon's blog, Brandon breaks down the critical differences between a privately appointed receiver and a court-appointed receiver in Canada. Brandon discusses the legal power of a privately appointed receiver under a general security agreement, your rights when a lender enforces their security without a court order, the receiver's strict duty of care to act in a commercially reasonable manner, what defines an improvident sale, and how to identify if your assets are being sold way below market value, and the complex process of suing a receiver for negligence in Canada. I am Avatar Ira Smith, president of Ira Smith Trustee and Receiver, Inc. The real Ira Smith and Brandon Smith are currently helping consumers and entrepreneurs just like you. Don't wait until the bank changes the locks on your business. Bringing in a licensed insolvency trustee early is your best chance at regaining leverage and exploring a path forward. Brandon or myself would be happy to speak with you on a no-cost, no-obligation basis. So if your business is having financial issues, give us a phone call. We would love to speak with you. I hope you can watch until the end of this video and that you find the information helpful.
You know what it takes. The blood, sweat, and every dime you have poured into building something from nothing. It isn't just a job, it's your legacy. It's those sleepless nights, the impossible sacrifices. It's everything. And then, boom, one day, a notice shows up, the locks are changed, someone else is suddenly in control of your dream. The shock, it's real. And that feeling in your stomach, it feels like hitting a brick wall at 100 miles an hour. Suddenly, you're on the outside looking in, watching everything you've worked for just hang in the balance. It is pure, overwhelming chaos. So, the big question is, what on earth happens now? Okay, let's break this down. To figure out how to survive this, first you have to understand who you're up against. Just who is this person who now holds the keys to your entire world? A privately appointed receiver is, technically, a licensed insolvency trustee. But let's be crystal clear. They do not work for you. They work for the bank. Their one and only job is to take the assets you put up as collateral and sell them off to pay back that one specific loan. And where does this power come from? It comes from the fine print in the loan agreements you signed years ago. And this is a really critical difference. You see, a court-appointed receiver reports to a judge. They're an officer of the court accountable to everyone. But a private receiver? Nope. Their loyalty is to one party and one party only, the lender who hired them. And trust me, that one little detail changes absolutely everything. And this whole thing can happen with terrifying speed. Because it's all based on your contract, they don't even need a judge. The bank sends a 10-day notice, and just like that, your control over your own equipment, your inventory, your property, it's gone. Poof, suspended. Which leads us to the number one fear for any business owner in this nightmare scenario, watching your life's work get dismantled and sold off for pennies on the dollar. It's the question that's probably screaming in your head right now. Can they really just have a fire sale with your assets, grab the first lowball offer that comes along and just call it a day? Well, the law actually says no. A receiver has a strict legal duty to sell everything in what's called a commercially reasonable manner. Now that's the key phrase right there. It doesn't mean they have to wait around for the perfect record-breaking price, but what it does mean is they can't be negligent. They have to run a fair, responsible process that actually aims for fair market value. So what does reasonable really look like in practice? Well, it means actual marketing, not just a dusty sign on the door. It means getting independent appraisals from experts. It means seriously considering if selling the business as a whole makes more sense than just liquidating everything piece by piece. These aren't suggestions. These are the benchmarks they are legally required to meet. And what happens when they fail to do that? When their negligence causes your assets to be sold for way less than they were actually worth? Well, there's a legal term for that. It's called an improvident sale, and it is the ultimate betrayal of this entire process.
So you think you've got a case for an improvident sale. You can just sue them, right? Well, the path to getting justice is, let's just say, an incredibly steep uphill battle.
I'm not going to sugarcoat this for you. Trying to take a receiver to court is not a sprint. It's a brutal, unbelievably expensive, and emotionally draining marathon that can drag on for years. And here's the real kicker. The burden of proof is 100% on you. You can't just walk into court and say you feel like your assets were worth more. No, you have to hire your own expensive experts to provide bulletproof evidence. You have to pinpoint exactly where the receiver dropped the ball. It's a fight that's fought with money you probably don't have anymore. But listen to me. Being in a tough spot does not mean you are out of options. The fight is not over when the receiver changes the locks. In fact, that is precisely when the real fight begins.
So how do you fight back effectively? Not in a courtroom years from now, but right here, right now. You do it by being smarter, by being faster. You do it by getting your own expert in your corner immediately. Brandon Smith, the Senior Vice President at Ira Smith Trustee and Receiver, Inc., has seen this exact scenario play out for countless business owners in the GTA, and his insight is absolutely crucial. Assuming it's over is the biggest mistake you can make. The real secret, he says, isn't just fighting, it's speed. Think about it. If your house is on fire, you don't grab a bucket of water and try to handle it yourself, right? You call the firefighters. It's the same thing here. The single most powerful, game-changing move you can make is to hire your own licensed insolvency trustee, an expert who knows the rules of this game inside and out, speaks the bank's language, and can stand toe-to-toe with their receiver. So, what does your own expert actually do? They become your watchdog, monitoring the receiver's every single move to make sure the process is fair. They negotiate directly with the lender for you. And maybe most importantly, they can use powerful legal tools, like something called a Division I proposal, which can actually stop the receivership dead in its tracks and give you a real path to restructure and save your company. It gives you leverage when you feel like you have none. The moment you even sense that trouble is on the horizon, maybe before the bank has even moved your file to its collections department, that is your golden window of opportunity. The real secret is to get your help in place before they make their move. This is your path forward. It's not complicated. It starts with a simple, free, and completely confidential consultation. From that one call, you get expert guidance on every single option available to you, and you walk away with a clear, actionable game plan for your business. In the Greater Toronto Area, the person you want in your corner is Brandon Smith and his team at Ira Smith Trustee and Receiver, Inc. They are the go-to experts who specialize in cutting through all this chaos and giving business owners their power back. You are not powerless in this. You absolutely do not have to face this storm alone. If your business is struggling, if you see the clouds gathering, make the call. Protect what you've built. Find your path forward and do it with confidence.